Welcome everyone. This is a video lecture on how to properly approach an essay for a bar or law student exam. We're going to give you some basic approaching principles, go over a model essay to kind of see how it actually works, and go over some analytical formulas to help you in your writing. We'll be brief and simple. All it requires is taking this basic approach and practicing it. I encourage you to take this approach, put it side by side with your fact pattern while you're practicing before the exam, and use it to keep you organized and make sure that you get all the issues that you need to do. So just let's begin. What we have over here is our writing approach. There are 7 basic guidelines. The very first thing that you're going to do is when you get an essay, you're going to read quickly through it to get an idea of the general understanding of the issues covered and the parties involved. If you're in law school, you probably already have an idea what subject you're in because that's the subject you're being tested on. But in the bar exam, there's so many subjects, you just need to put on that part of your brain that says, okay, this is a torts, this is a contracts, this is a remedies, this might be a PR exam. Okay, so you're not issue spotting, you're just getting a general idea of the structure of it. The second part, outlining the call to question, if there's a specific call or a regular call. If you find when you do the initial read through that it's a general discussion, then there's not a whole lot to start with. But if there is a specific call, you want to be sure to organize it. Your instructor and the examiners want you to make sure that you follow their instructions. That's one of the most important rules, is to answer in the order that they give it to you. Doesn't mean the facts are going to be given to you in that order, or the law that you learn in the structured order, but that's the way they want you to answer it. Okay, so on a torts essay, for example, this is a fact pattern with 1, 2, 3, 4, 5 paragraphs. Okay, I get an understanding that it's probably a semi-racehorse because it's broken up into little pieces. I'm looking at the bottom, what are the rights of Bill and Jane and what damages are available to them. So immediately I know that I have 2 plaintiffs, okay, and they could be listed together or separately. So it's important to know not to lump in all of your plaintiffs at once sometimes, okay. So I'm looking through it. Upon retirement, they get a home, they make a down payment, several months later it's taken away, she goes through some distress, the people that take their home have it, and they incur all these damages to the home. Okay, alright, so I kind of have an idea. Like I said, this is a torts essay, maybe some intentional torts, some negligence, but I'm not really grasping in detail. I'm not spending too much time on this. Okay, so we're going to back up, and since outlining the call of questions, I do it by parties as it's instructed in number 2. Okay, the second thing that you need to do, or excuse me, the third, is you need to go deep into the essay. And this is one of the most critical parts, is the examiners give to you the issues. You just need to recognize them. If any of you remember those posters from the 90s, those that you would stare and there was a castle that if you let your eyes go blurry enough, all of a sudden this image would appear. That's very similar to a fact pattern. Okay, so let me give you an example. If you look here on the right, if you force yourself to pause after every set of punctuation, connection words, paragraphs, you will see that the examiners are telling you to pause and recognize what the issues mean. Okay, so you may not always know what it means, but at some point you may just need to guess. Okay, sometimes it's relevant, sometimes it's not, but most of the time you need to address it. So I've got upon retirement, comma, Bill and Jane. Okay, they buy a specially designed home, comma, custom-built home, mobile home trailer from dealer. So I'm looking right here. I got to see 2 plaintiffs upon retirement, and that probably means they're elderly. They, they're separating the specialty maybe for torts. I won't go too much more into detail. We circle our ands. We stop at our periods. Okay, the highlighted areas are possible parties. Okay, so it gives you an idea of where they talk about the parties, because you need to go as simple as identifying what Bill and Jane are. Are they the defendant? Are they the plaintiff? You need to start from a very basic. These examiners can't be, you can't assume that the graders are going to know anything. Okay? So we see it. We see ands, periods, commas. Okay? Finance had erroneously repossessed the Mason's trailer, comma, believing it was the property of stranger. Okay? Well, there are two issues in here, in one sentence. Erroneously repossessed. Okay? That's shows that the actual causation that they did, in fact, commit some tort. Okay? Believing it was the property of the stranger. That's their defense. So we have the causation and the defense in one sentence. This is going to happen over and over and over again. Okay? For example, look further down. It would cost $500 to repair the dent, but the damage is neither serious nor noticeable. Okay, that's more of a conversion type, compensatory damages. Okay, so now that you got an idea of how the punctuation is really critical in forcing yourself to pause, this helps you spot the issues. Every set of punctuation and whatnot, they're telling you to stop, tell them what it means. Go back to the writing approach. So what I mean by the split outline approach, I'll show that to you in a minute, is you're going to write each significant fact with law. If the issue is unknown, you circle it and move later. Come back to it later. So basically draw a line down the center of your page. Your facts go on one side, your law goes on the other. And you take each fact upon retirement. That would be a fact on the left side. What does retirement mean to you under the law? I don't know. You may not know at this point, especially since you've never read this essay. Next below, Bill and Jane Mason. Okay? They are the plaintiffs. Purchased. Proper party. Specially designed custom-built home trailer. That's another fact, separated. That would be potentially their damages. If it's something that's special, that's gonna that you could even argue the return of the property from dealer. That's the defendant for $65,000. Every time you get a number, you better think that that's going to apply for the damages. Okay, they made a down payment of $10,000, and dealer retained a security interest. Okay, so each fact. What does this mean? What does this mean? What does this section mean? Okay, you got to pause, and then I'm not going to go through the whole essay about what each part, what law applies to everything. Okay. When you're done with that, you're going to review the outline, and you're going to pull out your issues. Now we know that Bob and Jane were the plaintiffs. We want to organize it by that eventually. But if you're so focused on organizing at this point, you're going to miss issues. So you just need to focus on writing headings. What does $65,000 mean to you? Expectation damages of $65,000. In that heading, we have a fact of $65,000, and we have the area of law or element or issue, as you want to call it, that's listed. So the grader will see, hey, I know exactly what that person's talking about. From dealer, well, the dealer is a potential defendant, so we, dealer as a defendant, and then you can further discuss that. Let me get into something more specific. Okay, something that you'll spot easily. The trailer was removed from Dream Park by agents of finance company. Okay, we got an issue of respondeat superior, right? So, agents, employees of finance company, liable under respondeat superior. It's a long heading, but it's drawing the attention of the grader to look at the issue that you've spotted for him. Okay, once you've kind of created 15 to 20, this is a mathematical formula. If you don't have enough issues, you're not going to pass the exam, no matter how well you write. Because if you write too much on an issue, you're going to lose time. So, focus on writing 3 or 4 sentences per issue, no more, and move on, because you'll bury that issue if you write too much. The grader has a checklist of how many issues that they need to have in order to pass you. Yes, discussion is important, but spotting all of the issues is even more important. So focus on, when you're done writing, look at your exam when you grade and say, did I have enough issues? If I don't have at least 15 and 20, I need to go back in and probably separate a paragraph that I wrote too long on, or look further for issues I didn't spot. By applying the principles of stopping and all the punctuation. Okay, so then you're going to organize the subheadings pursuant to the major headings, or your subject outline approach. Okay, so you're going to start. This was pretty basic. We got torts here, and they didn't really give us a guide as to how to start. It's just what are Bill and Jane's rights, and what are the damages available to them. Okay, so you need to reach back into your outline approach, which we can provide, and how to approach it. So whenever we have torts, you start from your intentional torts, and you go all the way down your checklist, all the way to the miscellaneous torts or defamation, however you ended up. For example, in contracts, you start with formation. If you don't have a valid contract, you can't even bother going to damages. So start from point A and go through your checklist, and you organize your issues per that. So in this case, or in this fact pattern, they give you a bunch of information about damages. Well, we usually address damages at the end. The tort doesn't occur, until the second paragraph. Damages occur at the third paragraph. So they don't give you the facts in the order that you need to write them or present them. So once you've kind of organized your subject matter headings into the pursuant to your outline and the call to question, you're going to fill in the facts. Like I said, no longer than 4 sentences per subheading. Okay. Now, when I say subheading, if you're going to discuss defamation, well, you can argue that so-and-so, not in this fact pattern, but Bob has an argument for defamation, the following issues will arise. And then you go through and you would discuss all of that. Same thing with negligence. They will assert a claim of negligence, and then you would go through your subheadings or the issues that the facts support. If there aren't any facts to support it, I don't recommend that you write a sentence all about with full of law, because they don't give you points for just telling you how much law you know. You need to really apply it. Okay. Let me back up here. Now, the place that a lot of students make mistakes is they don't review your outline for unchecked, missed facts or issues. You've got your outline in front of you. Make sure you've addressed everything and said, you know what, I'm not going to write about that, or I forgot about writing about that. So you need to go back and check to make sure that you didn't, because numerous times I've had students say, I saw that but I didn't write it. That's the point. When you feel that, you know that you've missed some issues. Okay. Just finally, quickly, what I have here is what we call the analytical formulas on helping you build a sentence structure. Okay, we have 2 analytical formulas: conclusion, because, elements and facts; since, facts, elements, and conclusion. You're thinking, well, what does that mean? Okay, so let's use this. The 2 things that you really need to remember are because or since. I always think of Dorothy of the Wizard of Oz, because. Well, let's see how that works. Let's deal with a real simple issue. The trailer was removed by Dream Park by agents of finance of company. Okay. Finance is liable for the actions of Dream Park, since they are the agents. Now let me back up. Finance is liable for the actions of Dream Park because they are the employees or agents thereof of finance. So it's liable under respondent superior for negligence or any actions because they're the agents or employees, and it states agents. So agents kind of is redundant, but that's what it takes, is doing that. So let's try it under this approach. Since they were agents of finance company, they are liable under the issue of respondeat superior. that was real basic, a little bit rough, but I hope you kind of saw the point. I was trying to think on the spot here, which sometimes you need to do, and it's sometimes refreshing. If you ever need to do figure out how to connect things and you're just at a loss, here's some helpful transitions. But other than that, just keep at it. I recommend taking this writing approach and using it while you're starting your initial practice, taking an essay and going through it like I said, pulling out the punctuation, and you should be all set. But like I said, the more like I'm going to emphasize now, you need to do a lot of essays. If you're doing just 2 or 3 or a handful, you're not doing enough. You need to do at least 6 to 9 essays per subject to really get it. You need to see the issues twice to really, once to kind of mess up, and the second time to say, I see it, I'm going to write about it. When you are done writing an essay, don't just look at the answer and say, okay, I got it, I missed those issues. Go back in and write it. Another tip is keep track of your time. When you're writing your essay, note where the hour mark fits. Most of you will be taking under an hour time constraint. Keep writing and finish your essay so that you note where you should have finished or how much time you needed. And so what you'll see is that if you apply this approach, you won't ever get to that hour or go over it, because you'll be writing some little compartmentalized subheadings. So good luck to you, and we'll look forward to posting additional videos about something you may need.